Dear friends, thank you very much for accepting my request for this important engagement. I formally welcome you all. Today, I propose, my dear friends, a very, very important engagement that is about refugee status determination. And in this particular engagement, we are going to deliberate refugee status determination, its dynamics, procedures, the rights of refugees, the rise of restrictionism, and the state obligations beyond the United Nations Convention relating to the status of refugees of 1951 and other important developments which have taken place or have been taking place in this connection. In addition to this particular submission, my dear friends, in this particular engagement, we are going to appreciate on critical footing the application of artificial intelligence in refugee status determination, impact of algorithmic humanitarianism, and other important international human rights engagements, requirements, and other important facets relating to asylum, which we have been deliberating for the last 3 weeks. My dear friends, refugee status determination procedure involves certain minimum standards for the procedural access, the principle of confidentiality, burden and standard of proof, establishment of the credibility and the benefit of doubt, and many other important requirements which are generally taken into considerations, including inclusion clauses, exclusion clauses, and secession clauses. It means where does status, which is generally enjoyed by the refugees, I mean the refugee status, what are the conditions and situations where that status comes to an end? That has to be taken into consideration. In this particular context, therefore, my dear friends, I am going to share certain important readings, and I hope you might have received some of the readings as of now, but some additional readings I would also like to share with all of you, not from your examination point of view, but for the sake of research and understanding, for a proper contextualization of this particular engagement. Particularly handbook that has been provided or that has been prepared by the United Nations High Commissioner for Refugees, particularly the handbook on criteria and procedures determining the status of refugees that has been prepared by the UNHCR in 1979, and I have already mentioned this in my earlier submissions. Another important treatise that comes to my mind is the International Law Commission draft code of offenses against the peace and security of mankind, that was prepared by the International Law Commission in 1954. That must also be studied, and I am going to deliberate as well as share some of the important texts and experts of this particular treatise. There are certain specific questions, my dear friends, when we are grappling with the issue how to determine refugee status. What is refugee status determination? RSD in the abbreviated form, which is popularly known as. Who is responsible for the burden of proving the requirement of what we call of asylum or asylum claim? What are the thresholds of credibility corroboration in RSD or refugee status determination? What are the procedural standards, access, and aspects of the refugee status determination that has to be taken into consideration? Another important facet is what is artificial intelligence and how does artificial intelligence impact, my dear friends, RSD procedures and govern certain specific what we call situations, particularly procedures and governance of human rights, availability of the human rights, international human rights requirements related to the asylum procedures are equally important, but how to appreciate them? What are the processes of refugee admission in countries of the global north that has to be taken into consideration? Another important question that is equally important is why is it important to focus on procedures and processes? What objectives can admission policies have? What are the current trends in the granting access to asylum seekers and refugees? And why does gender matter? What is the Dublin system of what we call of refugee status determination, and what is the importance of harmonization of 1951 Geneva Convention on refugee definition, and how to locate minimum standards for normal procedures, specific procedures, accelerated procedures, or manifestly unfounded procedure, and what is the idea of the safe country of origin. So therefore, we are supposed to understand what are the levels of risk, role of the past, what we call persecution, and discretion of the RSD officials. These are some of the important points which must also be taken into consideration. At the same time, what are the protected grounds which we have already studied, my dear friends, at length? I mean, the grounds, the 5 important grounds which have been identified in the definition clause when we were discussing in our earlier classes, when we were deliberating the idea of a definition or who is a refugee, particularly race, religion, nationality, political opinion, and particularly imputed political opinion, and the neutrality, social groups, and asylum claims based on what we call gender, and what is the distinction between a political and a non-political offense that has to be taken into consideration in this particular engagement. And do the victims of what we call of terrorist acts make a difference to the nature of the acts? Can involuntary acts, my dear friends, constitute assistance in persecution, and should they disqualify applicants from asylum? What is the appropriate standards? That appropriate standards must be identified, but at the same time, application of artificial intelligence, my dear friends, in refugee status determination procedures and impact of algorithmic humanitarianism dimensions must also be taken into consideration. The other important dimensions that has been raised by the application of artificial intelligence, and that is, are artificial intelligence induced solutions discriminatory? That has to be taken into consideration. Before I proceed further, it is equally important at this stage, my dear friends, to understand what is artificial intelligence. What do we mean by artificial intelligence? That has to be taken into consideration. My dear friends, when ordinary people come across, when ordinary citizens of a geopolitical entity accost or hear this particular term artificial intelligence, the first thing and the first idea they usually think of of robots, because the big budget films and novels weave screenplay about human-like machines that wreak havoc on Earth. There are a number of movies you might have seen in your life as teenagers, as adolescent, and right now as in your prime youth. You might be seeing and witnessing a lot of scientific what we call movies. Therefore, we can say that artificial intelligence is based on the principle that the human intelligence can be defined in a way that a machine can easily mimic it and execute tasks, from the most simple to those that are even more complex, and its goals include learning, reasoning, and perception. My dear friends, today there are many, websites. You might have, browsed some of the important, websites where the artificial intelligence induced what we call, softwares are also writing our, CVs. They are preparing, I mean, GPT kind of, technologies developed by, Google. They are they are having, and they have been impregnated or programmed with a lot of, intelligence to write as per what we call your keywords. You simply enter keywords and they will come out with a paragraph. So the reasoning and perception is being, developed, and that is why, that is known as ADM technology. So therefore, the ADM, what we call automated decision-making technologies, advances previous, benchmarks that defined artificial intelligence, almost what we call, became or become, outdated. For example, machines that calculate basic functions or recognize text through optimal character, what we call, recognition are no longer, my dear friends, considered to embody artificial intelligence, since this function is now taken for granted as an, inherent computer, what we call, function. Artificial intelligence, therefore, is continuously evolving to benefit many different industries. And the machines are wired using a cross-disciplinary approach based in mathematics, computer science, linguistics, psychology, medical sciences, including law and beyond. So therefore, we can understand, my dear friends, the roots of artificial intelligence, as I have already on some occasions I have, submitted in the class, my dear friends, that the John McCarthy, an American computer scientist, developer and inventor, was known as the father of artificial intelligence, having played a groundbreaking role in defining the field of artificial intelligence dedicated to the development of intelligent machines. The cognitive scientist, my dear friends, devised the term in his 1955 proposal at the first Dartmouth, conference on artificial intelligence, if I'm not wrong, I think in 1956. The objective was, in this particular, conference, the objective was to explore ways to make a machine that could reason like human, was capable of abstract, thought, problem solving, and self-improvement. Therefore, John McCarthy believed that every aspect of learning or any other feature of intelligence can in principle be so precisely described that a machine can be made, or can, what he call, simulate it. John McCarthy created, my dear friends, in 1958, the Lisp computer language, which became the standard artificial intelligence programming language. And today it is being used not only in robotics, but other scientific, applications, but in a plethora of internet-based services, from credit card fraud detection to the airline scheduling, or air travel, scheduling. It is all artificial intelligence, my dear friends, has also facilitated, or rather also paved the way for voice recognition technology, including Siri, the personal assistant application on the latest, iPhones. So therefore, the question that arises at this stage, and that must also be attended, the question that I have put forward at the initial stage, and that is, what is artificial intelligence? My dear friends, artificial intelligence denotes to the simulation of the human intelligence in machines which are programmed to think like humans and mimic human actions. The term artificial intelligence, my dear friends, may also be applied to any machine that demonstrates traits associated with the human mind, such as learning and, problem solving. The ideal feature of the artificial intelligence is its ability to what we call rationalize and take actions that have the best what we call chance achieving a specific goal, including refugee status and determination decisions. Therefore, we can take into account the applications of the artificial intelligence technology, and we find We find, my dear friends, ever since the evolution of artificial intelligence have started taking its shape, it has become countless and endless. The evolution of artificial intelligence in its applications have become some kind of a perennial process, and it can be applied to many different what we call sectors and industries. Today we can say that no sector where the human involvement has been identified is free from the application of artificial intelligence. Artificial intelligence is being tested and used in the healthcare industry for dosing drugs and different what we call treatments in patients, and for surgical procedures in the operating room. In other examples, or for other examples, my dear friends, we can take into account the functioning of machines with artificial intelligence, include computers that play chess and self-driving cars. Each of these machines must weigh the consequences of any actions they take, as each action will impact the what we call ultimate result or end results. For example, in chess, my dear friends, the end result is winning the game, but in case of self-driving cars, the computer system must what we call account for all external data and compare it to act in a way that prevents any kind of collision or any kind of accident. Artificial intelligence, my dear friends, also has applications in the financial industry, where it is utilized to detect a flag activity in banking and finance, such as unusual debit card usage and large bank accounts or deposits. The artificial intelligence applications are also being used to help streamline and make trading easier by making supply, demand, and pricing of securities easier to estimate. Therefore, algorithms often play a very important part in the structure of artificial intelligence, where simple algorithms are used in simple applications, while more complex ones help frame strong artificial intelligence applications. Artificial intelligence, my dear friends, is being used across different industries, including finance, healthcare, law, and justice. The weak artificial intelligence, my dear friends, it tends to be simple and single task oriented, while the strong artificial intelligence carries on tasks that are more complex and more what we call human like. So therefore, artificial intelligence has also been categorized into two different what we call forms, like the weak artificial intelligence and strong artificial intelligence. My dear friends, the weak form of artificial intelligence embodies a system designed to carry out one particular job, and this includes, my dear friends, the video games such as the chess, or other important what we call examples which I have already shared, like personal assistants such as Amazon's Alexa, Apple's what we call Siri. If we ask the assistant a question, it answers it for us. That is the what we call requirement. Whenever you enter into a room and it is completely what we call wired and with the Wi-Fi systems, and it has been what we call designed on the basis of artificial intelligence applications, and when you enter your room, either you clap, immediately there is a light, or you simply order, Alexa, switch on the light, the lights are on. Play a particular song, you simply order that it start the geyser. So all these kinds of what we call gadgets are artificial intelligence driven what we call electronic gadgets. So you can very well understand what is the importance. So a specific or single task which have been provided to any kind of a device, and that takes the commands. So that basically functions on the basis of artificial intelligence applications. But there is another important category which is known as the strong artificial intelligence. My dear friends, the strong artificial intelligence systems are mechanisms that carry on tasks considered to be human-like. These mechanisms, my dear friends, tend to be more complex and complicated systems. These systems are programmed to address situations in which they may be required for the solution of problems without having a personal, what we call, intervention. These kinds of systems can be found in applications like what we call immigration, screening self-driving cars, or in hospital operating what we call, rooms. But there is also some kind of a, criticism of artificial intelligence. And this criticism is equally important, and that must also be, understood. Because since its beginning, artificial intelligence, my dear friends, has come under scrutiny from scientists, legal luminaries, and the public alike. There is one common theme of understanding that machines will become so highly developed that humans will not be able to keep up. And they will take off on their own, redesigning themselves at a exponential what we call rate. Therefore, artificial intelligence machines can hack into people's privacy and even be weaponized, and other arguments debate the law and ethics of artificial intelligence and whether intelligence systems such as robots should be treated with the same rights as humans. And this is the most important, question which I have also, raised, my dear friends, in my what we call, another important, course structure that has already been accepted from the, next year, and it is going to be introduced from the next year, and that is artificial intelligence and the law. This is a very, very important question which I have also raised in that course structure. Another important dimension is relating to the self-driving cars. My dear friends, the self-driving cars have been fairly controversial, as their machines tend to be designed for the lowest possible risk and the least casualties. If presented with a scenario of colliding with one person or another at the same time, these cars, the self-driving cars, would calculate the option that would cause the least amount of what we call of, damage or casualties. Another contentious issue that comes to my mind is that many people have with artificial intelligence and how it may affect human employment. With many industries looking to automate, my dear friends, certain jobs, including refugee status determination, justice, and border what we call control system through the use of intelligent machinery, there is a concern that the people would be pushed out of the workforce. Therefore, artificial intelligence technology may remove the need for human controlled border programs, while automated decision making machines manufacturers may easily replace humans with artificial intelligent machine, making people's skill more what we call obsolete. So in such a situation, my dear friends, it is equally important how to have the application which is humanitarian in character, which is humane. When we are using the word humane, it means we are talking of the sensibilities and sensitive what we call technology. It means all these kinds of technologies must be free from any kind of what we call of biases, any kind of what we call of prejudices, any kind of discriminatory practices. So that has created some kind of a thin end of the wedge, and how we are going to what we call apply it, and how we are going to understand this entire what we call plethora of understanding, which is full of what we call of artificial intelligence induced issues, while applying these what we call technologies in the arena of artificial intelligence, in the arena of what we call not only of artificial intelligence driven mechanisms, but how to have a better understanding of the artificial intelligence in RSD mechanisms. My dear friends, when we are talking of refugee status determination, and in the subsequent arguments, I will try to what he call, locate the place and the, manner in which the artificial intelligence is applied to this particular, idea of RSD, that is the refugee status determination mechanism. So what is the importance in the contemporary circumstances, how to determine the status of a refugee with that of artificial intelligence? But before inducing or before invoking artificial intelligence, let us try to understand what exactly is the refugee status determination. My dear friends, a person is a refugee the moment he or she meets the criteria of 1951 United Nations Convention relating to the status of refugees with its additional protocol of 1967 or other relevant national, regional or international instruments which have been specifically designed for this very purpose, and that is refugee status determination. Both states, my dear friends, and Office of the United Nations High Commissioner for Refugees have an obligation to provide international protection to refugees. The document, my dear friends, not only the documents, but documents confirming protected and civil status also have an important protection dimension. A person's refugee status exists independently of the formal recognition. Governments have procedures to distinguish between refugees whom they have an obligation to protect and other persons who do not need international protection. Fair protection processes are those which receive, register, and determine refugees' claim or refugee status, what we call, entitlements in a timely manner and in accordance with the international and regional protection standards. The process whereby the authorities of the host country or the United Nations High Commissioner for Refugees or UNHCR in the abbreviated form establish that an individual who seeks international protection is actually a refugee. That is, he or she meets the eligibility criteria under international as well as what we call regional refugee instruments, national legislations, or UNHCR's mandate is referred to as refugee status determination. So here lies my primary question, which I have, put forward for your consideration at the very threshold of my today's, submissions, and that is, what is refugee status determination? My dear friends, in all possibilities, you are going to have this question in your end-term examination as well. What is refugee status determination? So the words, my dear friends, refugee status determinations are forbidding and legalistic. But the process they refer to concerns human beings usually in circumstances of great distress. Let me express it more in the simplest possible manner. My dear friends, when we use these kinds of terms or these kinds of expressions like refugee status determination, then these words, my dear friends, corresponding to question, is Mr. X or Mr. Y a refugee? That is the implication. The answer to this question is obviously of vital concerns to the individuals concerned. If recognized as a refugee, my dear friends, a special legal regime applies to them and they will be entitled to a number of important rights and benefits. Not only the rights and benefits, but as well as assistance and protection measures, which, if put together or taken together, constitute what is known as international refugee protection. I have already explained this particular term within inverted commas called protection. Refugees also have certain obligations towards the host state, notably that of abiding by the laws of the host country. Therefore, the refugee status determination means an examination by a government authority or UNHCR of whether an individual who has submitted an asylum application or otherwise expressed his or her what we call requirement for international protection is indeed a refugee. That is, whether his or her situation meets the criteria specified in the application, what we call application of refugee definition or applicable refugee definition. A person does not become a refugee by virtue of a recognition decision by the host country or the UNHCR, but is recognized, my dear friends, because he or she is a refugee. Let me put it in other words. The recognition decision is declaratory. It should be on your fingertips, because there is every possibility, my dear friends, tomorrow you may be the part of such organizations, international organizations, non-governmental, international non-governmental organizations who are working in the field of what you call refugee protection. Therefore, the recognition decision is basically a declaratory decision. It acknowledges primarily and formally and confirms that the individual concerned is a refugee. That is what we call, though who is a refugee, that particular question I have already what we call put forward for your consideration as per the definition clause that has been provided in 1951 Refugee Convention. But my dear friends, when this question what we call comes again, whenever such question, who is a refugee, arises, prior to the Second World War, refugees were defined, my dear friends, this should not be forgotten, on the basis of ad hoc what we call basis, with reference to their national origin. Following the war, United Nations General Assembly decided to adopt a general refugee definition, which has been provided in the UNHCR statutes. I'm not talking of convention, my dear friends. Here, 1950 statutes, which has also become the part of what we call of the subsequent United Nations sponsored convention relating to the status of refugees, with its additional protocol of 1967. These two important instruments are identical formulations, and both the instruments, my dear friends, have also been what we call utilized and used in defining the what we call a refugee and what exactly are the contours of a refugee or the refugee definition. Even, my dear friends, subsequent circumstances have also critically appreciated it, and whatever the resolutions have been adopted by the United Nations General Assembly in this connection have also been, my dear friends, appreciated by the United Nations General Assembly and Economic and Social Council. And the refugee definitions are also contained in regional refugee instruments, as well as many other important national legislations. So the convention definition we understand, my dear friends, but if you take into account, my dear friends, some of the most important what we call definitions which have been provided at regional level, which I have already submitted, but I am reminding you at this stage, whatever the definitions in addition to 1951 convention, particularly the 1969 OAU convention governing specific aspects of the refugee problems in Africa, and the 1984 Cartagena Declaration on Refugees, these two important regional orientations of the refugee definitions should never be forgotten, because both provide that persons fleeing indiscriminate threats resulting from the situations in their country of origin may also be recognized as refugees under specific and certain circumstances. Therefore, present refugee status determination is confined to the universal definition contained in the 1951 convention, and it is essential, my dear friends, for decision makers working in countries which apply the wider refugee definition set out in regional refugee instruments to understand the importance of these definitions. Since these definitions complement that of the 1951 convention, countries applying them should first examine whether an applicant meets the eligibility criteria that has been envisaged, stipulated, and propounded in the schematization of the definition that has been provided under 1951 refugee what we call convention. So it is very, very important. At this stage, it is equally important, my dear friends, take the example of 1969 OAU Convention. In this particular, convention, my dear friends, the term refugee shall also apply to every person who, owing to external aggression, occupation, foreign domination, or even seriously disturbing public order in either part or the whole of his or her, country of origin or nationality, is compelled to leave his or her, place of habitual residence in order to seek refuge in another, place outside his or her, country of origin or nationality. That should be the, importance. And this definition developed out of the experience of the wars of the liberation and decolonization which erupted in the African continent during the late 1950 and early 60s. Article 1, subclause 4 and 5 of the 1969 OAU Convention, my dear friends, also contains secession and exclusion clauses which differ in some respects from that of what we call, the clauses, secession and exclusion clauses which have been provided under 1951 Convention. Similar is the case with that of what we call of 1984 Cartagena Declaration, my dear friend. The refugee definition or concept of a refugee to be recommended for the use in region is one in which the addition to the, containing the elements of the 1951 Convention and the 1967 Protocol includes among refugee what we call persons who have fled their, country of, origin because their lives, safety, and freedom have been, threatened or by generalized violence, foreign aggression, internal conflicts, massive violations of the human rights or other circumstances which have seriously disturbed the public order. So that is the, beauty of this particular, 1984 Cartagena Declaration. And this is not formally binding, my dear friends. Many, despite the fact it is a soft law, many Latin American countries have incorporated its principles, including its refugee definition, into their own national what we call, legislations. So that should also be taken into considerations. And that is another important what we call, exercise that requires that the Latin American nation states, Latin American countries over the years have accorded the greatest amount of what we call of, sacrosanct, greatest amount of, integrity as well as, loyalty to the definition and understanding which have been provided under this, declaration. And despite its being a non-binding what we call, declaration, many of the national legislations have incorporated the mandate of this particular, declaration. But this is not the, situations in our part of the world, and that is, South Asia. But there are, some important what we call, thinkers, particularly Professor B.S. Chimney. Of late, he has already started advocating ever since the global compacts have been, adopted by the, majority of the geopolitical entities. Professor Chimney was of the view, and he has also deviated from his, traditional understanding that which he has, advocated vehemently in the, more than for the last more than 3 decades. Now he has also changed his position, and he is of the view that government of India should reconsider its decision, and the government of India must also, come out, including rest of the, South Asian national, governments. They should come out with a ratification proposal, or rather, the entire, South Asia must ratify 1951, Convention. Though Afghanistan is one nation in entire, South Asia that has already acceded to the mandate of 1951 Convention. Another important, aspects so far the, refugee definition is, concerned. We should not forget, my dear friends, the national legislations. Many states simply adopt the refugee what we call, definition found in the relevant international instruments or instrument to which they are party. There is nothing to prevent a country, my dear friends, from adopting a refugee definition that is wider than that required under its international obligations. In a number of countries, legislation provides protection for persons who have been found not to meet the criteria of 1951 Convention, but also, or who are nevertheless in need of international, protection. This is referred to as a complementary what we call form of protection, or in Europe, that is known as the subsidiary protection, or idea or concept of the subsidiary protection. In some states, particularly in Europe, have also provided idea of temporary protection or concept of temporary protection in situations where large number of people had fled situations of generalized violence and or armed conflict as a pragmatic short-term measures to provide those affected with protection against refoulement and assistance without, however, making a determination of their status. My dear friends, the refugee definition under UNHCR's international protection mandate is equally important. The United Nations High Commissioner for Refugees mandate is to provide international protection to refugees originally stems from its 1950 statutes, which provides that the competence of the High Commissioner shall extend, my dear friends, in addition to those considered refugees under treaties and arrangements in place at the time when the statute was adopted. And certain important what we call categories have also been visualized. And these categorizations have also been provided, my dear friends, in certain specific paragraphs of 1951 convention. Suppose the paragraphs 6A, subclause second. Any person who, as a result of events occurring before 1st of January 1951 and owing to well-founded fear of being persecuted for reasons of race, religion, nationality, or political opinion, is outside the country of his or nationality, and other important what we call expressions which I have already deliberated in earlier what we call submissions. Another important paragraph, that is paragraph 6B. That is equally important, and that must also be taken into consideration when we are talking of how to extend what we call protection. Therefore, the refugee definition contained in 1950 statutes of the UNHCR is nearly identical to that of the 1951 convention, that definition which have been adopted under this particular convention. Therefore, 1950 statute does not provide for membership of a particular social group as a ground for persecution, and its refugee definition has been, or has from the very outset, my dear friend, been applicable without any kind of restrictions. Therefore, 1950 statute is no longer encompasses the entire mandate of the UNHCR with regard to refugees, but it is the beauty of 1951 convention refugee definition that what we call encapsulates the rest of the dimensions which require refugee protection. But the later developments are equally important, my dear friends. In particular, resolutions adopted by the General Assembly and the Economic and Social Council, organizational and state practices ultimately resulted in a widening of the refugee definition for purposes of the UNHCR. In the late 50s and 60s, my dear friends, United Nations General Assembly authorized United Nations High Commissioner for Refugees to provide assistance on a good offices basis to specific groups of persons who did not fully meet the refugee definition contained in the statutes, including, for example, maintained, in mainland what we call China, particularly in Hong Kong, or Angolian refugees in Congo, or generally to refugees who did not come within the competence of the United Nations organization. And from the mid what we call 60s onwards, my dear friends, resolutions of the United Nations General Assembly regularly refer to refugees of concern to UNHCR. While ECOSOC and the General Assembly resolutions adopted during the period from 1975 up to 1995 have extended UNHCR's competence with regard to the refugees, generally to persons who are affected by the indiscriminate effects of the armed conflicts or other man-made disasters, including, for example, foreign domination, intervention, occupation, or colonialism. That must not be forgotten. So these kinds of what we call refugees have been designated in the popular what we call terminologies, or in the expressions that has been used by the United Nations High Commissioner for Refugees or the Office of the United Nations for refugees is known as the mandate refugees. The term mandate refugees refer to persons in either what we call category who have been recognized as refugees by the High Commissioner on the basis of 1950 statutes and the subsequent General Assembly and ECOSOC or Economic and Social Council resolutions. Therefore, mandate refugee status may be determined individually or on the basis of group determination. So question at this stage that arises is, why is it necessary to conduct refugee status determination? That is the second important question. In order to be, my dear friends, to answer this question, for the sake of effective, pragmatic, and efficacious implementation of specific obligations, the obligations which have been identified under 1951 Convention with its additional protocol of 1967, states must determine who is a refugee. This requires some kind of a procedure. The procedures which make it possible to establish whether a particular individual falls within the refugee definition of 1951 Convention or not. For United Nations High Commissioner for Refugees, providing international protection to refugees is its core function. And in order to exercise its mandate responsibilities, the office may need to determine whether an individual is a refugee within its own competence. UNHCR normally conducts a refugee status determination to ascertain whether the person concerned should be protected, assisted, or sometimes resettled to another country, or to give government's advice on refugee status. So this is how, and that is the what we call relevance and mandate. That establishes the necessity why it is necessary to establish or to determine a refugee status. Then there is a third question to it. Who is responsible for conducting refugee status determination? My dear friends, the primary responsibility for identifying those who come within the refugee definition lies with the country in which such persons have sought asylum, and that is the country of asylum. Refugees can actually, my dear friends, benefit from international protection and enjoy the rights and entitlements which are attached to refugee status. For the country concerned, my dear friends, protecting refugees is not simply a matter of convenience. Status which are, or in other words, let me put it like this: international states or the nation states or geopolitical entities which are party to 1951 Convention with its additional protocol of 1967 and 1969 OAU Convention are bound by these instruments to provide the protection guaranteed therein to women, men, girls, and boys who meet the criteria of the relevant refugee definition. The most important obligation, therefore, my dear friends, is that of ensuring respect for the principle that the states cannot return a person to a country whether his or her life or freedom would be at risk for reasons of race, religion, nationality, membership of a particular social group or political opinion. And this fundamental principle, my dear friends, must never be forgotten, and this is particularly known as the principle of non-refoulement. It has therefore become a norm of customary international law, and such as is binding on all states, whether they are party to 1951 Convention or not. Because as I have already submitted on earlier occasions for your consideration, my dear friends, that the principle of non-refoulement does not require any kind of a recognition by the geopolitical entities. If any state or any geopolitical entity today in the contemporary circumstances claims to be a civilized nation state, then it is the primary responsibility of that very state to recognize this fundamental principle of the customary international law. This fundamental, when we are talking of the customary international law, my dear friends, customary international law is inherent in the nature of the nation states. It is inherent in the nature of all the geopolitical entities. It is a fundamental principle of the state behavior, and it belongs to that particular era, my dear friends, where the states are having some kind of a pre-socio-political existence. It is prior to the formation of a state, it was inherent in the nature of what we call the nation states, that they must recognize, and it has always been coterminous with the existence of the nation states. That is the beauty of what we call the customary international law. And when something is recognized as a part of what we call the customary international law, there is no possibility of any kind of an exemption, deviation, or any derogation therefrom. So it is inherent. And that is my understanding, my dear friends. This is how I perceive this very fundamental principle of what we call of non-refoulement. The state, therefore, we can say, state should normally establish procedures and conduct refugee status and determination exercises, in particular if it is a signatory to 1951 convention along with its additional protocol of 1967. Under paragraph 8 of the 1950 statutes and article 35 of the 1951 convention, UNHCR has a responsibility to supervise the application of the provisions of 1951 convention and 1967 protocol, or additional protocol of 1967 in states which are party to these instruments. The UNHCR exercises its supervisory role, my dear friends, by monitoring both the procedures and the criteria applied and through interventions on behalf of applicants and as and where appropriate or it deems necessary. In most states, in majority of the geopolitical entities, provisions has been made for the involvement, for the acquiescence of UNHCR, at least in an advisory or consultative capacity. In some countries, my dear friends, UNHCR actually participates in the national refugee status determination procedure. For example, we can cite Afghanistan. Depending on the circumstances, this may take different what we call forms. For example, preparing a case for consideration by the National Eligibility Authority. For example, registration, preliminary interviews, file preparation, presentation to the national authority, voting on the asylum application, or participating as an observer, advisor, consultant at the first instance stage, where it is generally appreciated whether somebody should be recognized as a refugee or not on the prima facie basis. Voting on the asylum application or participating as a consultant or advisor in the review procedures or at the stage of review. Reviewing inadmissibility or rejection decisions of the applicants who are due to be expelled from the country of what we call reception. In certain countries, therefore, my dear friends, which are party to 1951 convention or its additional protocol of 1967, but where national asylum determination procedures have not yet been established, UNHCR conducts a refugee status determination on behalf of the state. So therefore, it becomes necessary, my dear friends, that there are certain important procedural standards. And there is a requirement for the implementation of specific procedural standards. What are the specific procedural standards? Number one is, my dear friend, access to what we call procedures and right to remain in the country of asylum or country of reception or country of refuge or country of shelter. Second important, procedural standard is the right to information about the procedure to be followed. Third is right to a hearing with a qualified official, right to an oral hearing, right to a qualified interpreter, right to counsel, right to written reasons for rejection, right to know the case to be met, or right to review, in other words, right to review evidence, right to have fair credibility assessment, right to an impartial decision-making process, right to access appeal procedure. Attention to the needs of the vulnerable persons is another important facet to all these kinds of what we call of, standards. On the part of the, United Nations High Commissioner for Refugees is the UNHCR also has a responsibility, therefore, to provide international protection to refugees and seek permanent solutions to the problem of refugees. UNHCR, therefore, my dear friends, remains the only international organizations with a specific mandate to protect refugees at the global level. Under its 1950 statutes and subsequent resolutions adopted by the UN General Assembly and ECOSOC, UNHCR has a mandate to ensure international protection and seek appropriate solutions for refugees within its competence. And therefore, asylum seekers are also among the categories of the persons of concern to UNHCR. There are many other important categories of the persons of concerns to UNHCR, like returnees, stateless persons, and under certain circumstances even internally displaced persons. They have also been perceived as persons of concerns to UNHCR. While states, particularly those which are party to 1951 convention, my dear friends, should normally conduct refugee status determination themselves. But in certain specific circumstances, UNHCR may need to conduct its own refugee status determination and establish for itself whether or not particular individuals or members of certain important groups are refugees within the office international protection mandate. In the majority of the cases, my dear friends, office does not perform RSD on the basis of 1950 statutes. But in practice, RSD may occur at a variety of contexts, including in countries which are not parties or not party to 1951 convention or 1967 protocol, or in countries which are party to 1951 convention, but where asylum determination procedures have not yet been established, national asylum determination process is manifestly inadequate, or where determinations are based on an erroneous interpretation of 1951 convention, or as a precondition for the implementation of the durable solutions such as resettlement. In most cases, my dear friends, where UNHCR conducts a refugee status determination, this is done for the purpose of establishing of or whether a particular person is a refugee within the competence of the United Nations High Commissioner for Refugees. My dear friends, the decision reached are of direct relevance also in the determining the form of protection and assistance provided by the UNHCR to the person concerned. These might include, if I'm not wrong, documentation particularly certifying the person's refugee status, measures to reunite families or reunite with the families, or to facilitate voluntary repatriation, or material assistance of the different kinds or multiple kinds. Then there is another important ancillary question that arises: how is refugee status determination conducted? Both states, answer is, my dear friends, both states and the UNHCR conduct refugee status determination either individually or on the basis of group determination. Let us take first individual what we call refugee status determination. My dear friends, neither the 1951 convention nor 1967 additional protocol prescribe a particular procedure for the determination of refugee status by state parties. National legislations defines the institutions and other important authorities who are involved, the stages of asylum process, as well as the procedural safeguards and guarantees. Whenever possible, refugee status should be determined in an individual procedure and following an in-depth examination of the individual circumstances of the applicant's what we call status. It has always been recommended that normally the individual refugee status of determination should be preferred. There is a case, my dear friends, Bolanga versus Refugee Status Determination Officer and others. My dear friends, in this particular decision, it has been held, or it was held, that and it has also been what we call, declared in this particular, decision, that the applicant is a refugee entitled to refugee, asylum, what we call, status in the Republic of South Africa in terms of Section 3 of the Refugee Act of 1998. That is a specific piece of legislation passed by the Parliament of, South Africa. And this is the decision of, my dear friends, of 1998. The assessment of the evidence should be carried out according to the standards set by UNHCR and the qualification, directive. Assessment of the evidence should be based on the facts provided or proved as true, should indicate why a specific fact was considered as true, and should indicate why a specific fact was not given any kind of a credibility at the stage of adjudication or critical appreciation. Such an analysis should make reference to all the facts stated by the applicant and should never consider as stated a fact which has not been mentioned by the applicant. Therefore, the information about the different stages of the procedure should be provided to applicants in a clear manner, preferably in writing the applicant's language. I can also share another important instance in Albania, my dear friends. In the first half of the 2015, 50 people, mostly of Iranian origin or Syrian origins, were granted asylum following the granting of EU candidate status to Albania in June 2014. In Albania, my dear friends, a new law on asylum approved in September 2014 replaced the provisions of the 1998 law. In this new law, further develops RSD, what we call standards based on the 2005 EU directive on minimum standards for granting and withdrawing refugee status. So therefore, a more generous what we call interpretation has been provided in terms of the individual refugee status determination in this particular situation. There is another what we call side after individual determination of the refugee status. There is another side, group what we call or group based refugee status determination, because sometimes it has become very difficult, particularly in protracted what we call situations or massive influx of refugees in a particular geopolitical entity, and in the mass migration situation. In a protracted what we call mass migration situations, it is very difficult to determine refugee status, because the recognition of refugee status for groups is particularly relevant in the context of the mass influx of refugees. The persons seeking international protection arrive in mass influx and at such a rate as to render individual determination of their claims for refugee status impracticable. In situations of mass influx, my dear friends, states as well as the UNHCR often accord refugee status to members of a particular group on a prima facie basis. This is appropriate if most of those arriving in the groups can be deemed to be refugees on the basis of objective information related to the circumstances in the country of origin. And the latest case is of Ukrainian refugees. It is altogether a different story, and I do not want to create any kind of a political, dimension at this stage. Otherwise, yes, I should not, deviate from the, point. Whenever I meet you in the, in the classroom physically, I would be what you call attending this particular dimension, because most of the recent developments with regard to the what you call protection of refugees. Just a moment, please. Let me recharge the battery. So just a moment, please. Just a moment. Otherwise, it will go. So I would be more forthcoming on this particular what you call issue. So far, other important actions on the part of the global north government or governance architectures are concerned, we would be attending. And you have to, Mr. Sagar Verma, I request you have to remind me whenever we meet physically or in person in the class. Very important point I intend to share, but not at this stage. So where an armed conflict in one country triggers a mass exodus of refugees into neighboring or other countries, combatants may be mixed with the refugee what you call influx of refugee groups. The presumption of the prima facie eligibility for refugee status determination, my dear friends, does not include combatants. Active combatants, that is persons who constitute or continue to take an active what you call part in armed conflict, are not eligible for international refugee protection, but the situation is different for former combatants. Military activities are incompatible with the refugee status, my dear friends, but more fact of having taken part in hostilities does not qualify or disqualify a person from international refugee protection. In situations of the former combatants or for the former combatants who apply for asylum must first undergo a clarification of their status. If they arrive as part of a mass influx, the host state would need to separate them from rest of the refugees. Former combatants, my dear friends, may be admitted into asylum procedures only after it has been established that they have genuinely and permanently renounced their military activities or military engagements and are now, for all practical reasons, have become civilians, ordinary citizens. The claims submitted by such people or persons should be examined in individual refugee status determination procedures. Another important category is that of women. Men, girls, and boys recognized as refugees on a group basis enjoy the same status as persons who have been granted refugee status individually. Depending on the context, it may be necessary to establish, my dear friends, mechanisms for identifying individuals within the group who do not meet the inclusion criteria of applicable refugee definition or who may fall within the exclusion what we call classes. Therefore, under all circumstances, the idea is the protection must be provided against refoulement. And most significantly, my dear friends, the refugees enjoy protection against return to a country where they face a risk of persecution. This is known as the principle of non-refoulement, and it is the cardinal principle. It is a principle that has been recognized under customary international law and often referred to as the cornerstone of international refugee protection. It is explicitly provided under Article 33, subclause 1 of our of 1951 Convention. If you take into account, my dear friends, I am not able to what you call reproduce in verbatim the mandate of Article 33, subclause 1 of 1951 Convention, but it takes into account the idea of expulsion or return or returning a refugee to any manner whatsoever, to the situations, to the frontiers or to borders or territories where his or her what you call life or freedom would be threatened on account of the grounds which have been identified in the definition clause. Therefore, it is a formal recognition of the refugee status. It is basically the formal recognition of the refugee status, my dear friend, and that is not a precondition for protection against a refoulement to apply. Asylum seekers may be refugees. It is an established principle of international refugee law that they should not be returned or expelled pending determination of their status. So therefore, the principle of non-refoulement becomes very, very important. Because principle of non-refoulement in customary international law, and when I am using the word the customary international law, as I have already submitted, it is basically the prohibition of torture and cruel, inhuman, and degrading treatment, punishment we are talking of. And this reminds me of a very, very important decision that has been delivered by the European Court of Human Rights in 1989, and it is Soring versus United Kingdom. My dear friends, under this particular decision, it was Article 3 of the European Charter of Human Rights that makes no provision for exceptions and no derogation from it is permissible under Article 15 of the European Charter on Human Rights in times of war or other national emergency. This absolute prohibition of torture and inhuman or degrading what we call treatment under the terms of the convention shows that Article 3 enshrines one of the fundamental values of the democratic societies making up the Council of Europe. It is also to be found in similar terms in other international instruments such as 1966 International Covenant on Civil and Political Rights, 1969 American Convention on Human Rights, and is generally recognized as an internationally accepted in standards. There is another important decision, my dear friends, of 1991, again delivered by the European Court of Human Rights, that is Kroos, Varas, and others versus Sweden. My dear friends, in this particular decision, expulsion by a contracting state of an asylum seeker may give rise to an issue under Article 3 of the European Charter on Human Rights, and hence engage the responsibility of that very state under the convention. And convention is European Charter or European Convention on Human Rights, where substantial grounds have been shown for believing that the person concerned faced a real risk of being subjected to torture or to inhuman or degrading treatment or punishment in the country to which he has to what he call return, or he was returned. That is the situation. That is the importance of this kind of a principle. The exceptions to the principles, therefore, my dear friends, of non-refoulement are very narrowly defined. And rather, in my personal capacity as a student of international refugee law, my dear friends, I am of the view that there should never be any kind of an exception to this particular, though the exception clause has also been what we call incorporated as Article 33 subclause 2 of 1951 convention relating to the status of refugees with its additional protocol of 1967 that created some kind of a exception of the national security, exception of the what we call relating to terrorism or terror activities. Therefore, my dear friends, they are permitted only in the limited circumstances provided under Article 33 subclause 2. The benefits of when we take into account the idea of exceptions, my dear friends, Article 33 subclause 1 may not, however, be claimed by a refugee whom there are reasonable grounds for regarding as a danger to the security of the country in which he or she or who, having been convicted by a final judgment of a particularly serious crime, constitute a danger to the community of the host state or community of that very country. So the conditions in which, my dear friends, Article 33 subclause 2 of 1951 Convention may be applicable can only be met if a refugee poses a very serious future danger to the security of the host country, such as a threat to the country's constitution, territorial integrity, independence, or external peace, or he or she has been convicted by a judgment that is no longer open to appeal of a crime of a particularly serious character or serious nature, for example, murder, rape, armed robbery, and continues to pose a danger to the community of the host state. Therefore, the application of an exception under Article 33 subclause 2 requires procedures in which guarantees of the due process or the procedure established by law or rule of law may be strictly what we call, observed. Therefore, Article 32, subclause 2 of the 1951 Convention will not only apply if the removal of a refugee results in a substantial risk of the torture or cruel or inhuman or degrading what we call, treatment or punishment. The prohibition of reforma is an inherent part of the prohibition of torture and other forms of ill treatment, as has been, provided under Article 3 of the 1984 UN Convention against, torture, Article 7 of 1966, Covenant on Civil and Political Rights, and other important, regional human rights frameworks. Because the non-reformer, my dear friends, has arisen to the status of a preemptive norms of international law, or just cogence, you may call it, and as such, binding on all states, regardless whether or not they have become party to the relevant what we call, instruments. And in this particular, context, my dear friends, it is also worth noting that the non-reforma provisions contained in the 1969 OAU Convention, which applies to all those who meets its refugee definition, does not foresee any exceptions. The principle, therefore, the principle of non-reforma, my dear friends, as enshrined under Article 33 of the 1951 Convention, has developed into a norm of customary international law. And what does it convey? It means, my dear friends, that it is binding, even on states who are not party to 1951 Convention or 1967 Additional Protocol to 1951 Convention. Under international and regional human rights law, my dear friends, states are also precluded from returning to a person to a serious risk of violations of other, fundamental human rights. So that is the, situation, that is the, understanding, and this understanding under all circumstances must be maintained so far the application of the principle of non-reforma is concerned. So thank you very much for the day, my dear friends. I take your leave, and rest of the, submissions I will deliver tomorrow, if you allow me. At the same time, I may conduct your online class at 5:15 tomorrow, if you allow me, though I'm immensely thankful, immensely grateful to you that without any kind of a prior consultation with all of you, I simply requested and emailed you a link for today's class. So thank you very much. Now the floor is open for your questions. You may ask questions. You can also email me your questions, whatever the requirements you have. So
thank you, sir.
You're welcome. So see you tomorrow at the same time. Thank you very much. Thanks a lot for being with me. Bye-bye.
Thank you, sir.
You're welcome. Thanks a lot.
Sir, I think there was some network problem from my end. You asked me to do something.
Yes. Yeah, I will definitely let you know what I have asked here. Okay. So you have
Thank
to
you,
put
sir.
a question to me. You have
Thank
to
you,
put a question to me whenever we meet in person in the class. So that is the only request. So that will remind me what I am supposed to deliberate. Thank you very much.
Thank you, sir.
You're welcome. Thanks a lot. Take care. Bye-bye.